You know, when the plaintiff files a lawsuit in federal court, the plaintiff and the opposing counsel both have an option consenting to the magistrate judge having jurisdiction over the case. And what does that mean? That means that the magistrate judge makes decisions, specifically the motion to dismiss, defendant's motion to dismiss. And when the magistrate judge makes the recommendation, he or she sends it to the district court judge who makes the final decision. But let's go back to the magistrate judge. After the magistrate judge makes his or her recommendations, then the plaintiff has an opportunity to object to the magistrate's recommendations. And let me ask you a question, plaintiff. Why would you not want to object to the magistrate's recommendations, particularly because the law and the facts are on your side? In other words, your case has merit. Because if you don't object, you potentially waive your right to appeal matter. And that's what we're going to talk about today. Plus, we're going to talk about the argument that can be used by a plaintiff, the argument against waiving your right to appeal. And we're going to use case law to illustrate the point. So let's get started. And we're going to look at Snyder versus Nolan. It's a 2004 case, Seventh Circuit. So let's look at the facts. On September 17, 1998, plaintiff Snyder sued defendant Nolan, a court clerk under 42 U.S.C. 1983. Snyder alleged Nolan violated his constitutional right of access to the courts. The magistrate judge recommended dismissal on the ground Nolan's action was quasi-judicial and entitled him to absolute immunity. Snyder timely objected. The district court dismissed the complaint with leave to refile on the ground that it was unclear to the judge hearing the matter from the complaint whether Snyder was suing Nolan in his official or individual capacity. On April 6, 2000, Snyder filed a second amended complaint to correct the previous one, and Nolan filed a motion to dismiss. The magistrate judge recommended that the complaint be dismissed. Snyder did not file objections. And on February 23, 2001, the district court adopted the magistrate judge's report and recommendation and granted Nolan's motion to dismiss. On March 7, 2001, the district court entered judgment for Nolan. On March 16, Snyder filed with the district court a motion to vacate the judgment and, in the alternative, a notice of appeal. So the issue before the Seventh Circuit is whether Snyder has waived his right to appeal. Nolan submits that because Snyder failed to timely object to the magistrate judge's report, he has waived his right to appeal all factual and legal issues to this court. Snyder concedes that he did not object to the magistrate judge's report. However, he maintains that the interests of justice require a finding that his right to appeal has not been waived. So let's look at the court's analysis. The Seventh Circuit cited Thomas v. Arnn, in which the Supreme Court held that, consistent with the requirements of due process, a court of appeals may adopt a rule conditioning appeal when taken from a district court judgment that adopts a magistrate's recommendation upon the filing of objections with the district court identifying those issues on which further review is desired, so long as the rule provides clear notice to the litigants and an opportunity to seek an extension of time for filing objections. In a nutshell, an appellate court can require that a plaintiff file an objection to a magistrate's recommendations as a prerequisite for filing an appeal to the district court's adoption of the magistrate's recommendations. In other words, if you don't object, you can't appeal. However, the court further provided that because this rule is a non jurisdictional waiver provision, the Court of Appeals may excuse the default in the interests of justice. This circuit adopted the rule, concluding that failure to file objections with the district judge waives the right to appeal all issues, both factual and legal. However, the circuit stated, we also recognize that under certain circumstances, the failure to file objections may be excused because the rule is not jurisdictional and should not be employed to defeat the ends of justice. So, what is a non jurisdictional waiver provision, or what is the effect of it? It prevents a party from giving up their right to challenge jurisdiction by not raising it immediately or at a time certain. In a nutshell, it ensures that the plaintiff can still assert jurisdiction later on. For example, Snyder, even though he did not object to the magistrate's recommendations within the time required, and is usually 14 days, he did not automatically lose his right to appeal. And so decided the Seventh Circuit Appellate Court, finding we decline to apply waiver in this case because doing so would defeat the ends of justice. The court continued, we cannot accept Mr. Nolan's contention that waiver should be applied in this case because Mr. Snyder's failure to receive the magistrate's report was due to his own fault in failing to notify the court clerk of his change of address. The record simply will not support such a finding of fault on the part of Mr. Snyder. Notably, the court continued, the record contains no indication that Mr. Snyder in any way departed from the prison's normal course of procedure. Accordingly, we decline to hold that Mr. Snyder waived his right to appeal. Now, someone may be asking, what if Snyder had received the court's report and recommendation? Does that mean he would have lost his right to appeal? I would say no, not automatically, because justice supersedes a waiver. So let's say Snyder did receive the report and recommendation timely. There could have been many reasons why Snyder did not object. And still, the court would look at what's best in the interest of justice. So here are two takeaways from this video. One, object to the judge's recommendations. If you believe that your case has merit and you have the facts and the law to support it, object to the judge's recommendation. Two, invoke in the interest of justice. If you find yourself in a situation like Mr. Snyder, and like he did, invoke in the interest of justice. I trust this video has been helpful to you. And as always, I'm Advocate Lucinda, and we will see you next time. Take care.